Good morning, everyone. It's 9:01, so we'll get started. So welcome to Wilkin Chapman's latest webinar, this time on Life After Brexit. I'm Oliver Tasker, partner in the employment law team at Wilkin Chapman, and today my role is that of host, rather than presenting on topics such as furlough or the job retention scheme, which I'm sure many of you will be relieved about that we've got a different topic to talk about today and something other than COVID. COVID's really taken the limelight away from Brexit and the looming deadline come the end of December this year. And from the 1st of January, free movement for EU national ends and new immigration controls kick in from that date. So today we're going to be hearing from immigration specialist and solicitor Calum Hanrahan. And really, he's going to be covering three main topics for you today. Firstly, the EU settlement scheme. Secondly, the new points-based system and the future skills-based system that will come into force. And finally, the UK sponsor licence application process and reporting duties upon businesses as well. So in terms of housekeeping, if you do have any questions as Calum is talking, then if you put these in the Q&A box, which you'll find at the bottom of your screen, and time permitting, Calum will answer these at the end. If you have any technical difficulties at all, fingers crossed you won't, but if you do, pop those in the chat function and Taryn, who's in the background, will get back to you and try and assist you with those. Finally, if you do want to ask a question at the end, again, as long as we have time, if you raise your hand when we get to that point, which again, you should find at the bottom of your screen or perhaps at the top of the screen, then we'll cut to you in terms of audio and you will have that opportunity to ask your question. One final reminder is that the webinar is recorded and therefore the recording will be available to everybody who's signed up after today, and we'll be sending a link out as part of our follow-up. So, Calum, over to you.
Thank you, Ollie. Perfect intro. Little for me to say really before getting stuck into the content of the webinar. Just perhaps a little recap. For those who haven't met me before, my name's Calum Hanrahan and I'm a solicitor specialising in immigration law. The purpose of the webinar today really is to ensure that you're aware of the significant changes that will be taking place in terms of UK immigration from the beginning of next year. If you have an existing EU workforce, what you can do to protect that workforce before the changes and what you'll have to do in terms of that workforce and future recruitment after the changes have taken place. There will be a requirement in the future for a UK sponsor licence if you wish to continue to employ or recruit from outside of the UK. So I'll talk through the sponsor licence, the reporting duties, procedures that will be in place. Now, just before we start off with the EU settlement scheme, which is the first of the three topics I'm going to talk about, I think we have a poll that we're going to put up just to really get an understanding of who currently employs EU nationals. So that should either appear on your screen or be at the taskbar at the bottom, I understand. So we'll just give that a minute or two for people to get their votes in. And it's looking quite good so far. A high percentage do employ EU nationals. So hopefully I've got the right audience before me this morning, and we'll just give it, in fact, I think that's everyone who's now voted. So a high proportion of you do employ EU nationals, so hopefully you'll find what I'm going to talk about highly relevant. Some of this information you may already know. Hopefully there will be a few pieces if you are aware of the scheme that you can pick up on. So I'm just going to get rid of that from my screen and off we go. So, the EU settlement scheme. This forms part of UK law, so will no longer be governed by EU regulations. And although it's called the EU Settlement Scheme, it does include EEA nationals and those nationals of Switzerland. For ease of reference, really, I'll refer to all of those as EU nationals, and I'll specify if anyone else is perhaps exempt. So, for instance, Irish nationals are not required to apply to the scheme. They can apply if they wish to, but there's no requirement to. And the deadline to apply is the 30th of June 2021. However, the EU national must have been resident in the UK by the 11 p.m. on the 31st of December this year. So there isn't too long to go really until we hit that deadline. And there are two different types of statuses available. There's settled status and there is pre-settled status.
So Calum, can you just explain for everybody what's the difference then between that settled status and the pre-settled status?
Yes, of course. So I'll start with settled status first. And in order to qualify for settled status, the EU national must have lived in the UK for a continuous 5-year period. What that means is that for at least 6 months in any 12-month period, the EU national must have been resident in the UK. Now, there are 4 exceptions to that. The first is a period of absence for up to 12 months for an important reason. Examples being childbirth, serious illness, or an overseas work posting. Compulsory military service for any length of time is the second exemption, and time spent abroad as a Crown servant. Finally, any time spent abroad as a member of the armed forces will cause an exemption. The applicant must have been living in the UK, so resident, by 11 p.m. on the 31st of December 2020, and the deadline to apply is the 30th of June 2021. Now, you'll probably get sick of hearing those dates as we go along, but they are incredibly important, which is why I will be repeating them and highlighting them throughout the course of the webinar. Now, the benefit of the new scheme compared to the EEA regulations is that the EU national does not need to prove that they are a qualified person. Previously, they'd have to do that through employment, self-employment, studying, being self-sufficient, or actively seeking work. There is no requirement to prove your economic activity. It's purely based on residence in the UK. Now, when settled status has been acquired, it will only be lost really for 2 reasons. One, if the EU national leaves the UK for a continuous 5-year period. It's a 4-year period for Swiss nationals, or if the EU national commits a serious crime. This is the status that all EU nationals really should aspire to obtain. It's the equivalent to indefinite leave to remain for non-EU nationals. And what that means is there is no requirement for any future visa applications or extensions. You're classed as being settled in the UK, obviously settled status, that's what the name suggests. And settled status is a prerequisite for an application to naturalise as a British citizen. There's no obligation for EU nationals to do that, but it's something which is quite important, I think, that they are aware of. Now, in terms of pre-settled status, this is issued to applicants who've been resident in the UK for less than 5 years. Again, they must have been resident by the 11 p.m. on the 31st of December 2020, and the deadline to apply is the 30th of June 2021. Leave to remain will be granted for a period of 5 years, and the expectation is that within that 5-year period, the EU citizen will then apply for settled status when they hit the 5-year mark. Now, pre-settled status will be lost if the EU national leaves the UK for a continuous 2-year period. And it's really important that if that is a possibility, the EU national considers the implications in terms of a settled status application. This will only be granted for 5 years. So if you then leave the UK for a 2-year period, they're not going to be able to hit the 5-year residence requirement needed. for settled status in the UK. So, in short, settled and pre-settled status mean that the holder can work in the UK, they can study in the UK, they can make use of the NHS, and they can access public funds such as benefits and also pensions if they're eligible to do so, and they can travel freely in and out of the UK, which from the EU nationals' point of view is probably one of the key points there.
So who should actually apply for the scheme then, Calum?
So almost all EU nationals, EEA nationals, Swiss nationals, and their family members who wish to remain in the UK. Those who have got permanent residence under the EEA regulations still need to apply. They'll transfer their current residence permit into settled or pre-settled status. Those who have a residence document under the EEA regulations need to apply. Non-EU family members need to apply. Those who hold indefinite leave to remain aren't required, but they may choose to do so. The main benefit there being if they've already obtained it through the immigration rules, they'll lose it if they leave the UK for a continuous 2-year period. They'll lose it if they leave for a continuous 5-year period if they apply through the settlement scheme. And an EU national who is naturalised as a British citizen can't apply to the scheme. There's absolutely no need for them to anyway, but any family members who haven't naturalised will need to apply if they're not British or Irish. And importantly, children must make their own applications. They won't be joined onto another family member's application. They make the application in their own right.
So you mentioned then about family members, and I know it's a question that you get quite a lot, but what about family members who want to join their EU family member after the end of December then?
So close family members who aren't living in the UK by the 31st of December 2021 will be able to apply to join their EU family members who were resident in the UK prior to that date, as long as the relationship existed prior to the 31st of December 2020 and the relationship continues to exist. So there's one exception there, and that's for children. There may be an occasion perhaps where a child hadn't been born prior to the end of December this year, but they were born after that date. And close family members are limited to spouses, civil partners, unmarried partners, dependent children, dependent grandchildren, dependent parents and dependent grandparents. All other extended family members must be lawfully residing in the UK by the 31st of December 2020 in order to apply and remain here.
Okay, which brings us on to our next poll, if we can launch that, please. And this time we're asking whether you've submitted an application previously to the EU settlement scheme, whether that's for yourself or somebody else. Just a couple more seconds to vote on that. So it looks like the majority haven't made an application for that. So Calum, what's the application process? Can you talk us through that side?
Yeah, of course. So generally, there are 3 things that you must do in order to make a successful application. First of all, you make an application and you prove your identity and your nationality. You prove the length of residence in the UK, and you undergo a criminality check. Now that's for over 18s only, not for children. The application process is mainly online. Applicants who are unfamiliar with online processes can contact the Home Office for a paper-based application, but the online application is so much easier. It avoids the need to submit any documents to the Home Office. You get to keep all of your documents, your original documents, and you tend to get a decision a lot quicker than if you had to send documents out in the post. So the key documents needed for an EU national, their valid EU passport or valid EU national ID card. And for a non-EU national family member, a valid passport, a valid biometric residence permit, or a valid biometric residence card if they've already applied for one. Now, I'm going to talk through the process from beginning to end, and this will be in terms of an EU national. So the first step would be to download the EU Exit ID Document Check application. It's available from Google Play or the App Store. And in order to download it on the Google Store, you must have an Android phone. To download it on an iPhone, it must be an iPhone 7 or higher. If you don't have an iPhone 7 or higher, the application won't work. But rather helpfully, you don't have to use your own phone. If the EU national has a friend who has the phone with the requirement, they can use that phone. So once it's been downloaded, you log in and take a photograph of the ID page of your passport or ID card. You then place the phone over the chip on the passport or ID card. And this really is where the magic happens. The application reads the information which is on the chip. You then take a scan of your face and take a selfie. And that deals with the identity aspect of the application. You will then log into the online application, again, which can be through a computer, a Mac, Windows computer, iPad, iPhone. And there will be 5 sections to complete. The first section is identity, and it will state it's been completed because you've dealt with it through the application. The second is the application type. This section, you'll enter if you're an EU national, if you're a non-EU family member, if you hold a residence card, or if you hold any other nationalities that may be relevant. The third section is to do with residence. So you'll enter your address, any previous names you may have been known by, you may have changed your name through deed poll, through a marriage, divorce, enter your national insurance number and whether you're applying based on less than 5 years residence or 5 years residence and more. The fourth section relates to criminal convictions. Clearly the Home Office want to identify those serious and persistent offenders and anyone who poses a threat to security. So a declaration will be required on the application, and you'll confirm if you have any convictions. If you do, you should state what they are. There are some questions which may seem a little odd, asking if you have any ties to terrorist organisations. All of these questions must be answered honestly. Criminality can be highly complicated, but it is important that each case is considered on its individual merits. And finally, you'll take a digital photograph. And this is the photo that will be used on the status document if the applicant is provided with pre-settled or settled status. Now, another clever aspect of the application, and the reason you insert your national insurance number, is because the Home Office will automatically check with HMRC and the DWP to confirm tax contributions, national insurance contributions, any benefits that have been received. Now, I mentioned earlier that there's no requirement to prove your economic activity, and that's not what's happening here. It's just a way of the Home Office to confirm your residence in the UK. Clearly, if you've been paying tax through employment, through self-employment, or you've been receiving benefits, you've been resident in the UK. If the applicant has been living and working for the period of 5 years and that's picked up, an email will come through to state that the settled status has been acquired. And if it's been for less than 5 years or there's not enough information with HMRC or the DWP, there is an option to include some additional documents. Again, this can be dealt with online. You can scan in up to 10 additional documents, upload them, they'll go to an assessor, and then you'll receive an email to confirm which status you have received. In terms of potential appeals, really there are three options available. If you're not happy with the status you've received, you can reapply. Simply start a new application. It may be that you answered one of the questions incorrectly by accident, or it may be that you didn't have documents to confirm your residence, which you do now have. You could apply to appeal the decision, or you could ask for an administrative review. This could be that you believe the documents you've provided are evidence of 5 years residence, and you can explain that and ask for it to be reviewed administratively. Now, in terms of the status being granted, there's no physical document. It's a digital form instead. So the EU national will receive a letter, an email to confirm the status they have received. And within that document, there will be a link to the government website whereby they can log on. They'll need the ID document used to submit the application, their date of birth, and then a secure access code will be either emailed or texted to them. And when they log in, they'll see the photo, the selfie that was taken, and it will clearly state whether they have settled or pre-settled status. Now, this can be shared with other people. Typically, it would be a potential or current employer in order to prove that they have the right to work in the UK. Now, it's really important for employers to note that at the moment, you cannot insist on EU nationals or family members of EU nationals to apply to the settlement scheme. They can still demonstrate their right to live and work in the UK with their current EU passport or ID card. And I expect this position will probably change from the 1st of July 2021, but not until then. Now, I've just had a message to say my connection's unstable, and I don't know if you can still hear me.
Yeah, I can still hear you, Calum.
Fine.
Yeah.
So in terms of important notes, just a recap of the EU settlement scheme. Settled status is a prerequisite to an application to naturalise as a British citizen in the UK. There's no obligation to proceed with that application, but it's helpful for EU nationals to be aware of it. Of course, there are some other requirements that would need to be met. I'm not going to cover them in this webinar, we simply don't have the time. Pre-settled status will be granted for a period of 5 years, and the expectation is that when you hit 5 years residence in the UK, you apply for settled status. EU nationals must be in the UK by 11 PM on the 31st of December 2020, and they have until the 30th of June 2021 to apply. If you do happen to miss the 30th of June 2021 deadline, there is an option to apply late, but only if there is a very good reason for the delay. A delayed application will cause an interruption to rights and entitlements, which is something to bear in mind. My firm advice, apply in good time for the deadline. Even if it's a case that the EU national hasn't quite met the 5 years required for settled status, apply for pre-settled status now. It just regularises their position and secures things for the time being. And one bonus, there's no application fee. It's entirely free, which is quite unheard of for UK immigration applications, as I'll go on to in a few seconds.
Thanks, Calum. So we've seen a lot in the media about the new skills-based immigration system that's going to come in. So can you explain about that aspect, please?
Of course. So the UK's future skills-based immigration system. You may also hear this being referred to as the skilled worker route, which is mainly how I will refer to it, and it's one and the same. So from the 1st of January 2021, if you want to recruit workers from outside of the UK's resident labour market, you will need a Home Office sponsor licence in order to do that. This will enable you to recruit workers from anywhere in the world. It obviously excludes British citizens and Irish nationals. We do already have an existing points-based system, and in reality it's being rejigged to take into account EU citizens as well as non-EU citizens. We're limited for time, and my focus for this webinar, this section, will really be on long-term routes, so formerly called a Tier 2 general route, rather than any short-term routes. If you're aware of them, they're referred to as Tier 5 routes. So the key changes: from the 1st of January 21, non-EU workers will be treated the same as EU workers, and they will require sponsorship to come to the UK to work. The Tier 2 general route will be replaced with the skilled worker route, and the Home Office are suspending the cap on how many skilled workers can come to the UK, which should save some time in the application process itself. The Home Office are also removing the need to perform something called the Resident Labour Market Test. This is a test whereby employers need to advertise within the UK to try and recruit domestically. Those advertisements would be for 28 days. The need for that is now being scrapped, which essentially means the process won't take as long because you don't have that 28-day advertising process to go through. However, it's important to note that the role should still be a genuine role to be filled. So the skilled worker route. This route will be open to individuals of all nationalities. They must have a confirmed job offer, and those whose employment will be sponsored by a UK employer must have a sponsor licence. They need to obtain points. It's called a points-based system, and 70 points is the magic number. Now, 50 of those points are for mandatory requirements. They're classed as being non-tradable. So, first of all, if you have an offer of a job from an approved sponsor, you obtain 20 points. If you have a job at the appropriate skill level, you'll obtain 20 points. And if you can speak and understand the English language to the appropriate level, you get 10 points. In terms of the appropriate skill level, when you identify whether a job meets a skill level or not, all of the jobs that you can possibly think of come under something called a Standard Occupational Classification, a SOC code. And each SOC code has a designated skill level. And this is what determines whether the job meets that level or not. The full list of the SOC codes allowed under this route were released in the summer in the government's policy statement, and they will in turn be placed into the immigration rules in time for the 1st of January 21. Just to consider the English language requirement, in order to meet that requirement, essentially there are four routes. You can be a national of a majority English speaking country, and they're defined by the immigration rules. You can have an academic degree taught in English. You can pass a secure English language test, or if you've shown that you meet the English language requirement in a previous successful application, it will be accepted that you meet it for the new application. Now, in addition to the 50 mandatory points that I've just spoken about, there are some tradable points. So clearly there are another 20 points needed to make the hit the 70-point mark, and they're in terms of your salary. So all applicants must receive a salary of £25,600 per year, or the specific salary requirement for their occupation in the SOC code, and this is known as the going rate. There are some tradable points here in terms of if the salary isn't quite high enough, you can possibly trade it off if the job is classed as a shortage occupation job, or if you have a PhD relevant to the job in question. Now, the salary is slightly different to people classified as new entrants. New entrants to the labour market are currently entitled to come to the UK on a lower salary than their more experienced counterparts, and they benefit from this reduced salary for a period of 3 years. And migrants will be defined as new entrants under the new system if they meet one of the 3 requirements. First of all, if they're switching from a student or graduate route to the skilled worker route. Secondly, if they are under the age of 26 on the date of the application. And thirdly, which is a new position, if they're working towards a recognised professional qualification or moving directly into postdoctoral positions. The recognised qualifications will be specified in the immigration rules. It would take some time for me to go through all of that now. And again, we don't have the time to do that. So really just to have a recap on the skilled worker route in terms of requirements that the applicant must meet and conditions and restrictions if the visa is issued. They have to meet the English language requirement. They will have to pay an application fee. They will have to pay an immigration healthcare surcharge fee. The employer will have to meet an immigration skills charge. And they'll have to confirm that they can maintain themselves if the visa is issued. Now, the way that's presented at the moment is you must have £945 in your bank account, clear in your bank account for 90 days prior to submitting the application. However, sponsors can tick a box in the application to confirm that they will provide that maintenance if needed. No money actually exchanges hands at all. It's just to confirm that if there's an issue, you would step in and help. Now, this route isn't capped, so there are no limits. Switching is allowed into alternative routes if that becomes relevant for the migrant worker. It does lead to settlement. Typically, if you've been on the route for 5 years and meet all of the requirements, you can apply to settle. Dependents can come with the migrant worker to the UK, but they will need to prove their dependency, and they'll also have to meet the application fees. There will be no access to public funds, and supplementary work is allowed. Now, I'm going to just talk about the health and care visa too. Now, this forms part of the skilled worker route, and it actually came into effect in August of this year, possibly created or certainly brought forward due to the impact of COVID-19, and certainly the frontline workers who have been working incredibly hard to try and keep everyone well and safe. So it's aimed at individuals of all nationalities who have a confirmed job offer, and the job offer is one of the defined health professions. Again, these are listed in the immigration rules, but typically would be a skilled job within the NHS, the social care sector, or for NHS commissioned services. The skilled jobs, and I'm not going to list them all, but a qualified doctor, a qualified nurse, health professional, adult social care professional. There is a fast track entry with reduced application fees for applicants and their dependents. Those who are eligible to apply will be exempt from meeting the immigration healthcare surcharge. Again, quite a big saving. And the main applicant must meet all of the requirements of the skilled worker route. So, for example, the appropriate salary, the English language requirement, and their job offer must be from a Home Office approved sponsor. One other route that I am going to touch on is the intra-company transfer route. Again, this currently comes under the Tier 2 General and will be covered under the new skilled worker route. But the purpose of this route is for multinational companies who have a presence abroad and in the UK to enable them to bring key workers to the UK if needed. And the route will require applicants in roles to RQF 6, which is a graduate level entry, which is higher than just the normal skilled worker route, which is an A-level entry. So the job actually being performed must be to a higher standard. And the minimum salary thresholds are slightly different. So they don't have to complete an English language test. There's no English language requirement. However, the worker being transferred must have been working for the business for at least 12 months prior to the transfer. If they are a graduate trainee, for at least 3 months. The route does not provide an avenue to settlement at all, which is quite important and is often missed when people are considering this route. And those admitted to the route will be permitted to switch into the skilled worker route, which does allow settlement, whilst they're in the UK if they meet the qualifying requirements. Again, I've already covered those. So a bit of a recap really in terms of the intra-company transfer. No English language requirement. There's still an application fee. There is an immigration healthcare surcharge fee. They need to confirm they can meet maintenance costs, or their sponsor can do that for them. They're not capped, and there's no limit at all. They can switch in country. No route to settlement. Dependents can come too. No access to public funds, and supplementary work can be carried out. In terms of the minimum salary requirement, that's £41,500 per year, or the going rate for the role, whichever is higher. So it's quite a bit higher than the skilled worker route, but clearly the job that they're coming to do is supposed to be of a higher level, so perhaps you would expect that. In terms of costs involved for an employer, if you wish to sponsor migrant workers, you have to pay the immigration skills charge. That's a fee that costs £1,000 for the first 12 months the skilled worker is in the UK for, and a further £500 for each subsequent 6-month period. Now, the rates are discounted for charities and small businesses. They're £364 and £182 respectively, but it's quite a big cost, and you can't then levy that on the worker that you're employing. You've got to meet that. There are application fees. I've touched on the immigration healthcare surcharge fee. That's £624 per year the visa is issued. They're fees that it's accepted and perhaps expected the applicant will meet. However, if this is someone that you think will be key to your business, then it may well be that you're quite happy to meet those fees, but they can be quite substantial. So,
yes, I was just going to say that brings us on to our third poll, actually, and the third topic that you will be speaking about. So if we can launch that poll, this time we're asking if you actually have a Home Office sponsor license already. So hopefully that poll will have appeared on your screen for you to vote for. We will give you another few seconds to vote, and then we'll publish the results of that. Yeah, okay, if we publish those results. So majority do not have a current Home Office sponsor license. So perhaps, Calum, if you talk us through the application and the reporting duties for the final section.
Of course, thanks, Ollie. I think that's quite helpful. So everything I go through should be relevant if you're considering sponsoring migrant workers. And for those who already have a licence, I may actually perhaps answer some questions that you may have in terms of what happens to that licence moving forward. When I put this together, it soon became apparent that perhaps this could have been a webinar on its own. So I have condensed it. I'm not going into a huge amount of detail, and perhaps that's a good idea, as the majority of you don't have a licence. I don't want to bombard you with too much information. So you can apply for a sponsor licence as an employer or an educational provider. I'm just talking about the employer sponsor licence here, not the educational provider sponsor licence. So the application is submitted online. It requires some fairly basic information about the business and about the reason for the application. The website is very old. The application process quite often involves the website crashing. It's a really good idea to save your application as you go along, just to save you having to repeat inputting the information. In order to be eligible, you can't have any unspent criminal convictions for immigration offences or certain criminal offences such as money laundering and fraud. And if you've had a sponsor licence previously, you can't have a history of failing to carry out your sponsorship duties. You'll need to provide supporting documents to the Home Office. Now, usually they would be sent in the post within 5 days of the application being submitted, and they would need to be original documents or certified copies of original documents. Due to the pandemic, the Home Office are currently accepting the supporting documents via email, and they're also accepting documents which have not been certified. However, they come with the caveat they may write to you to request certified copies or the originals. In a way, this is probably quite helpful because the Home Office receive the document straight away, and hopefully it should lead to the application being considered sooner than it normally would be. The usual timescales would be about 8 weeks from submitting the application, although you can now pay £500 to receive a decision within 10 working days. As far as I'm aware, that application process is still live. However, again, with the lockdown, I know the Home Office have been working with skeleton staff, and they have been suspended some of their priority services. I'm not sure if that one is suspended at the moment or not. In terms of the documents you would expect to provide, evidence of registration with HMRC to pay PAYE, accounts office reference numbers, business bank account statements, audited accounts, evidence of employer's liability insurance for at least £5 million. If it's an intra-company transfer, there needs to be evidence of the link between the entity from outside of the UK and the entity from within the UK. A number of different ways you can do that. Quite often an affidavit is a good way of dealing with it, attaching a company structure. You will need to select people from within the business who will undertake certain roles. These are really important. So the key roles, there are 4 of them. An authorising officer, and this is a senior and competent person really responsible for the actions of staff and representatives who use the sponsor management system. That's the system used to keep in touch with the Home Office about the migrant workers you employ. There's a key contact, which is the main point of contact for UK visas and immigration. If they have any queries, that's the person they'll contact. They may want to conduct a compliance visit. They'll contact that person and probably spend the day with them to go through your HR procedures, check you've got all of the documents and information on the migrant workers you employ. There's a level 1 user, and they're responsible for the day-to-day management of the sponsor license, and a level 2 user. This is optional, and they've got access to the sponsor management system, but it's at a limited level. It's not the same access that the level 1 user would have. Now, these roles can be filled by the same person or different people. It really depends on the size of the business and perhaps the staff members that you have available to complete and fill the roles. It generally is a good idea to have more than one person covering the roles, just in case someone's on holiday, if they're off sick, and issues arise that need to be dealt with. Now, the staff chosen for the roles will go through suitability checks, and you're unlikely to be issued with the sponsor licence if anyone involved has an unspent conviction, if they've been fined or reported to UK visas and immigration, if they've been a key person for another sponsor licence which has had its licence revoked within the last 12 months, if you've failed to pay VAT or other excise duty, and the staff put forward must be based in the UK for most of the time. Can't be a contractor or consultant contracted for a specific project. They can't be subject to a bankruptcy order, and they can't have a history of non-compliance with sponsor requirements. So in terms of the costs involved, the grand scheme of things, they're fairly minimal. The application fee is split between small businesses and charitable organisations and medium to large businesses. So the small business is classed as a business with an annual turnover of £10.2 million or less and have 50 employees or fewer. And they would pay £536 for the application. The application fee for medium to large businesses is £1,476. And if the application is successful, the sponsorship licence will be granted for 4 years. Now, it's really, really, really important that the date the licence expires is written down and highlighted, because if it's your obligation to extend the licence if required. If you don't do that and you sponsor migrant workers, you're then not allowed to sponsor that migrant worker and their visa will be curtailed due to you not extending your licence. So that's a really important practical point. In terms of responsibilities, you must check that the migrant workers have the necessary skill level, qualifications, accreditations to do the job that you're offering them. You must have copies of those documents and be able to show them to the Home Office if required. Only assign certificates of sponsorship to workers when a job is suitable for the sponsorship. Keep UK visas and immigration up to date if your sponsored workers aren't complying with the conditions of their visa. Say they go AWOL, you use the sponsor management system to update and inform the Home Office about that. And your licence can be downgraded and even suspended if you don't meet those responsibilities. So in essence, it's a really clever way for the Home Office to get you to pay them to do their job. But it's important that you do that. You've got to keep them up to date. In terms of HR systems, make sure that your employees, you've got all of the correct documentation in place for them to legally work in the UK. Keep copies of the relevant documents, so passports, right to work information, if they have applied to the EU settlement scheme, and you're not required to sponsor them, but if the Home Office do a visit, they're the documents they'll have a look at. They won't just look at the documents relevant to the nationals that you sponsor, they'll look at your HR systems as a whole. Keep the employee details up to date, so if they move house, you have to update that. If they change their telephone number, if they get married, change their name, that's all the general information you'll keep up to date on the sponsor management system. And if there are any changes to the business, you've got to report them. So if the business stops trading, becomes insolvent, there's a substantial change to the nature of the business, or if you're involved in a merger or a takeover, they're really important. They must be reported. Potentially, specifically if there's a merger or a takeover, it may mean that a further sponsor licence application is required, or if the takeover involves other entities within the UK, those branches may need to be added to the licence. So it's really important that you keep the Home Office up to date. We've covered quite a lot. I'm conscious of the time, and although I've not looked at them, I can see that we've got quite a few questions that have come through during the webinar itself. So I think possibly this would be a good time to run through some of those questions.
Yeah, we've got quite a few questions that have come in, Calum. So if I go through those and then over to you for the answers. So one that we've actually been asked for a couple of times is that what happens if we currently employ an EU national and they don't want to apply for settled status?
They don't have to. You can't force them to. But if you employ them at the moment, when it hits the 1st of July 2021 and they haven't applied, then they don't have a legal right to be in the UK and to work. So you'll have to terminate that employment in essence, otherwise the potential impact on you, you're employing an illegal worker, you could get hit with a £20,000 fine per EU national you employ. So it is a tricky situation because you can't insist that the workers, the EU nationals apply, my advice is just to make sure they are fully informed of the implications, and there are documents that can be downloaded from the government website, posters that can go around, information leaflets. Something I've done previously is to spend time within businesses who have a number of EU nationals to talk them through the process. I think the general view from inquiries I've had are perhaps some people aren't really aware of what they have to do or the implications, or they have the feeling, well, we shouldn't have to apply for this. We've been subject to free movement. Why is it ending now? It's ending, and they are going to have to apply. And if you want to keep them in the business, you're going to have to try and help them to do that, but obviously be as tactful as possible. You can't force them to make that application. So perhaps some business planning may need to be done on your part if it's looking like you may have to replace those EU nationals.
That's useful. And what really follows from that then is a question from Victoria, is that can an employer ask to see proof of settled status?
Not at the moment, no. So until the 30th of June next year, EU nationals can confirm their right to work through passport ID documents. If they have applied and they offer to share that with you, that's fine. You can accept that as proof that they've got the right to live and work in the UK, but you can't specifically ask for it at the moment. I suspect come the 1st of July, the Home Office position will change. They'll update their right to work guidance, and it will now state that they need to show that they've got a settled or pre-settled status rather than an ID document to confirm they're an EU national.
Yeah, you'd expect that to change, like you say, wouldn't you, in terms of providing that evidence. Next question is that if employees already have indefinite leave to remain, just to be clear, they don't need to go through the process and no further action post-Brexit. Is that correct, Calum?
Yeah, that's correct. If they've already got indefinite leave to remain, no need to apply. They may want to apply, and the main benefit is if it's already been obtained through the immigration rules as they are, they'll lose their indefinite leave to remain if they leave the UK for a 2-year period. If they apply through the settlement scheme, they've got a 5-year period before they lose it. So they may want to, but they don't need to. So there are no issues there if they decide that there's no action they want to take.
Okay, and another clarification point and question that we've got. So if an employer doesn't have a sponsor license, is it correct that they can't employ anyone outside of the UK? And Victoria states, assume this does not apply to anyone already employed prior to the end of December.
So if you don't have a sponsor license and you wish to employ non-UK workers who are not in the UK as of the 1st of January, then you won't be able to. If you already employ an EU national and you don't have a sponsor license, you won't need a sponsor license as long as they apply to the EU settlement scheme. If they don't apply to the scheme by the 30th of June 2021, you won't be able to employ them. But you won't need to apply for a license if you already do, and they do apply to the scheme. I can't hear you, Ollie. I don't know if you're on mute.
There we go. Can you hear me?
Yeah.
Good. Nikki asks, we recruit a high number of EU colleagues in our warehouse, which is classed as non-skilled. Would we still be able to in 2021?
It depends on the actual job that they are doing for the business. The immigration rules will be updated with a list of jobs, and if they're to the required RQF level 3, which is A level, and there is a job description. So if you feel that the role fits that description and you want to employ when the new rules come into play and they're not already here, so you have to get a sponsor license, then possibly. But if you class it as an unskilled job, then the chances are that you may not meet those requirements. But you need to investigate the actual specific job descriptions before making that decision.
So maybe Nikki could contact you afterwards, Calum, for a bit more guidance on that would be useful.
Yeah, of course. Yeah, we can speak after the webinar, get in touch and then go through that.
Yeah, good. Leslie asks, will students still be able to work outside of term time, and will there still be a maximum number of working hours?
As far as I'm aware, yes, they will still be able to work outside of term time. They'll be limited to the number of hours they can work during term time, but there won't be a maximum number out of term time. It's perhaps something I might pick up afterwards just to confirm that's still going to be the correct position. But as far as I'm aware, that's how things will be moving forward. Okay,
that's useful. Yeah, and Leslie will let you know in terms of that. Sue asks, you state that applicants need to, I think, be in the UK at 11 PM on the 31st of December. What happens if they go home to visit family over Christmas and New Year?
So my advice, if they're already in the UK, either now or before that deadline, submit the application for pre-settled or settled status. Generally, it takes up to a week for a straightforward application to be considered. So they'll then have that status before they leave the UK. If they haven't applied, then they're going to have issues. Although they may meet the requirements for settled or pre-settled status, if they don't apply before that deadline, then they're not going to be able to come into the UK under the EU settlement scheme. So submit the application.
Okay. What maybe ties in with that is a question from Nikki in terms of checking, I suppose, for evidence that somebody has been a resident prior to the 31st of December. What steps can really a business take, Calum?
So in terms of the business checking, I'm not sure really it's something that you would need to do. So if you already employ the EU national, clearly that's not an issue because you'll have gone through the right to work checks, you'll have seen their ID card or passport. If you're looking to recruit someone from within the UK, up until the 30th of June, you just need to see their ID card or the passport. I don't know if the question's changed slightly there.
That's useful. I think that should clarify that, Calum. Lisa asks, we employ quite a few students from EU, non-EU. What steps do we need to be taking in relation to those?
So in terms of the students that are employed, you will have gone through the right to work checks already. If they're here and they're non-EU with a student visa, that's not really affected at the moment. You just need to make sure that they're limited, or you're limiting the hours that they work to the requirements of the visa they have. Generally, I think it's 10 hours per week during term time, unlimited outside of term time. If those students are EU nationals, you just need to take copies of their ID at the moment, but if you continue to employ them after 30th of June next year, then they will need to have applied to pre-settled or settled status, unless they've then applied as students on a tier 4 visa in their own right, in which case it would be the same. Just making sure that the hours that are worked are correct and going through the normal checks.
Okay, final questions just very quickly, and that will bring us up to the hour perfectly. Again, it's just clarification If somebody's already got settled status, Calum, the business doesn't have to sponsor to employ them. Is that right?
Correct.
Perfect. Nice quick one to finish with there as well. That brings us to the hour perfectly. So thank you very much, Calum, for that. And thank you everybody that attended the Life After Brexit webinar today. In terms of follow-up, we'll be sending out an email so that you've got Calum's contact details should you want to get into contact with him and ask any further questions about Brexit and the steps that you need to be taken in terms of immigration. And we'll also be sending out the link to the recording as well as part and parcel of that. But all that leaves me to say is thank you very much to Calum, and thank you very much to everybody that's attended today.
Thank you.